Okay, let's unpack this. Step with us into a legal arena where the intense conflict of a long-running family dispute unexpectedly collided with the rigid procedures of the criminal justice system.
Yeah, and this wasn't just any court case. It became a really high-stakes battle that put the very foundations of fairness and procedure to the test.
Especially in some of the most sensitive cases our courts handle, right? Those involving alleged offenses against children.
Exactly. This is the deep dive into the case known as PJVR.
So what are we working with today? What are our sources?
Our guides today, through this complex landscape, are a collection of crucial documents. We're pulling key insights directly from the detailed judgment of the New South Wales Court of Criminal Appeal. That's the official, sometimes pretty technical record of the court's decision.
Right.
And alongside that, we've got analysis from expert commentary that helps us understand the case's broader significance for legal practice. We're really trying to extract the most important nuggets and insights from these sources to make sense of it all for you.
To reveal not just what happened, but why it actually matters.
Precisely.
Our mission here is clear then, to unpack this complex case layer by layer, maybe like peeling back the layers of a legal onion. Hopefully less tear-inducing, though.
Let's hope so.
We want to reveal the human drama simmering beneath the surface, trace the twists and turns of the legal procedure, get to know the people involved, and understand exactly how this case has left a real and significant mark on legal practice here in Australia.
And at its heart, PJVR is just a stark illustration of the justice system grappling with a fundamental, often really heart-wrenching dilemma.
That balancing act.
Exactly. It's the delicate balance between how courts attempt to protect vulnerable child witnesses from the potential trauma of testifying, while simultaneously upholding the accused person's fundamental right to a fair trial.
And their essential ability to fully challenge the very serious allegations against them.
Right. This case shows just how incredibly difficult that balance can be to strike.
Okay, let's set the scene. Act I, if you like. The spark of conflict and the early steps. So, the backdrop to this case wasn't a sudden event, was it?
No, not at all. It was a simmering, pretty toxic family law dispute that had been raging for 5 long years between the man known in court documents as PJ and his ex-wife, MD.
5 years.
Yeah. And this intense conflict seemed to reach a critical point just 2 weeks before the alleged offenses occurred.
Why then specifically?
Because that's when consent orders were made in the family court, finally granting PJ's specific access to the children after all that time.
And it was during this period of access that the alleged offenses took place.
That's right. Based on the sources, PJ was charged with 4 sexual offenses against his young daughter, referred to as FJJ. These allegedly occurred over the course of just 1 week, between the 28th of June and the 4th of July in 2021.
Specifically while the children were staying with him under those new family court orders.
Correct.
The sequence of events moved quickly after that week then.
Very quickly. On the 5th of July, 2021, FJJ made a complaint to her mother, MD.
And following that complaint,
MD took the children straight to the police, and statements were taken by the Joint Investigation Response Task Force, or JRU. That's a specialist unit handling these kinds of sensitive cases.
Okay, so the official process kicks in. Now,
Yeah.
PJ's response when confronted, the sources say it was immediate and quite traumatic.
Absolutely, and central to everything that followed. When he was arrested and interviewed by police, this is what's called an ERSP, an electronically recorded interview with a suspect, pretty standard procedure. On the 8th of July, 2021, PJ adamantly denied the allegations.
Okay, denial, but then...
And here's where the core of his defense emerges, right from day one. He claimed that MD had orchestrated these complaints to, and this is a quote, "wipe me off on the kids," alleging this wasn't the first time she'd done something like this.
He gave specifics.
He did. The sources recount a specific, really shocking detail he provided about a previous alleged incident. He claimed MD purportedly instructed their son, MLJ, to strip FJJ naked during a video call, supposedly to record it as evidence for the family court. And he declared to the police, and this is another quote described in the judgment, "She does that before to have evidence to wipe me off on the kids," she and her lawyer. Now she's doing the same thing again.
So this claim of a malicious fabrication plot, it was there right from his initial police interview.
Absolutely. Formed the absolute core of his defense and really fueled the central dramatic tension throughout the subsequent legal proceedings.
Right. So let's quickly introduce the key players, our sort of dramatis personae, in this unfolding story, keeping in mind the sensitive nature of it all.
Good idea.
There's PJ, the accused father, the applicant in this appeal, whose identity is shielded by a non-publication order. He maintains his innocence, claims he's the target of this malicious plot.
Then we have MD, the mother, PJ's ex-wife, who is alleged by PJ to have fabricated these complaints as part of their very bitter custody dispute.
Next is FJJ, the complainant, the young daughter, the alleged victim in this case.
And her brother, MLJ. The brother, the son. He's a key witness in the proceedings, alleged by PJ to have been involved in that previous incident orchestrated by MD, and whose potential influence over FJJ was something the defense really wanted to explore.
Okay, got the players. Given the sensitive nature of the witnesses, the first major procedural step wasn't a traditional courtroom hearing, was it?
No, it wasn't. It occurred on the 1st of April, 2022, a pre-recorded evidence hearing held before Judge Trail, who is a district court judge.
And the purpose of that?
Well, it operates under a specific NSW law designed for child sexual offense cases, the Child Sexual Offense Evidence Pilot Scheme. Its purpose is precisely to reduce the potential trauma for child witnesses.
How does it do that?
It allows their primary evidence and the defense's cross-examination to be recorded once, usually outside of the main trial environment, minimizing the number of times they have to recount difficult events.
I see. So at this hearing, both FJJ and MLJ gave their accounts and were then cross-examined.
That's right, cross-examined by PJ's legal counsel at the time.
And who was representing PJ at this absolutely crucial initial stage? Do we know?
The judgment refers to his legal counsel at this specific hearing simply as previous counsel for PJ. Their individual name isn't specified in the judgment itself.
Okay.
Although their solicitors throughout this process were NFK lawyers. The Crown's prosecutor at this hearing was Mr. Robinson.
Right. And here lies the critical omission, you said. The key point that set the stage for everything that followed.
Exactly. According to the sources, during this cross-examination, questions were asked about things like, MLJ's potential influence on FJJ, or about the children's general feelings about their father and the access arrangements. But the crucial and dramatic allegations PJ made about MD's alleged orchestration and fabrication of the entire affair his core defense raised right in his police interview were not put directly to the children.
Not at all.
No. Justice Hamill, in his later dissenting judgment looking back at this, would pointedly refer to these as significant omissions.
Wait, so his main defense, the thing he said in his very first police interview, wasn't put to the key witnesses? That seems incredibly significant.
It absolutely is. And the consequence was profound.
Why?
Because this pre-recorded hearing was intended to be the primary and often the only opportunity to test the children's evidence directly on these very points. The legal framework, particularly designed to protect child witnesses from having to repeat their testimony, strongly favors the finality of this pre-recorded evidence.
So failing to ask those questions then?
The failure to put PJ's core defense, his claim of a malicious plot orchestrated by the mother to the children at this initial stage, effectively erected a major legal barrier. It became, exceedingly difficult, if not impossible under the existing framework, to revisit those questions later.
Wow. That's a core tension that drives the rest of the case, isn't it?
It really is.
Okay, that definitely sets up a major problem for the defense. Which brings us to Act 2, the battle to reopen. So what happened next? Did PJ's legal team try to fix this huge omission?
Precisely. Following that initial hearing, there was a change in PJ's legal representation. His counsel from the pre-recorded evidence hearing became unavailable in September 2022.
Okay.
So by October 2022, PJ had briefed a completely new legal team to take over his case.
And this new team, tasked with handling this pretty complicated situation, who were they?
It was led by M. Avenel SC, that's senior counsel, indicating a more senior barrister, and S. Orman Hales, also counsel. They were instructed again by the same solicitors, NFK lawyers.
Okay.
And the sources note that Mrs. Fard of NFK lawyers was actively involved in this stage. The Crown side remained the same for now. The solicitor for public prosecutions, with Mr. Robinson continuing as the prosecutor at this district court stage.
So new team on board, facing the consequences of that critical omission. What was their move?
Well, the fight to have PJ's full defense aired took a critical new turn. On the 2nd of February 2023, they filed a formal application, a notice of motion, before the same judge, Trail DCJ.
What were they asking for?
They were seeking specific leave that's permission from the court under a particular section of the Criminal Procedure Act, Schedule 2, Clause 87, to recall both FJJ and MLJ.
In the goal?
The explicit goal, as stated in the documents, was to finally put to the children PJ's specific allegations about their mother's alleged role in fabricating their accounts, to fix that earlier omission.
Right. And here's where something quite striking happened, according to the sources. The stance taken by the prosecutor, Mr. Robinson.
Yes, this is really notable. The sources explicitly state that at this hearing in the district court, Mr. Robinson did not oppose this application for recall.
He didn't oppose recalling the child witnesses.
No, in fact, he presented arguments that could even be seen as supporting it. Things like acknowledging the difficulties a jury might face if the mother-influence theory remained unaddressed with the children, and the implications of legal rules, like the rule in Brown v. Dunn.
Which generally requires you to put your case to a witness you intend to contradict.
Exactly. That seems highly unusual, doesn't it? The prosecution not opposing the defense recalling their own child witnesses.
It certainly stands out in the documentation and commentary on the case. It suggests that, at least at this stage, maybe the prosecution also recognized the potential challenges for a fair trial if PJ's central defense couldn't be properly explored with the children.
Seems plausible. But despite the prosecutor's position, on the 8th of February 2023, Judge Trail DCJ delivered her ruling. She refused PJ's application to recall the children.
Okay. What was her honor's logic? What was the reasoning behind that refusal, especially when the Crown wasn't opposing?
According to the sources, Judge Trail's primary focus and the main basis for her decision was the potential for re-traumatizing the two young children by subjecting them to further questioning. That was paramount for her.
Okay, child protection focus.
Yes. She referenced another case, Oldfield VR, as suggesting an alternative approach where, in that case, a concession was made by counsel about potential influence rather than recalling a child witness. She viewed this kind of concession as a, quote, fair way of dealing with it rather than re-traumatizing two small children.
So she saw an alternative path.
Right. And crucially, she concluded that there had been no procedural unfairness because PJ had had the opportunity to raise these known issues. His claim of fabrication was known from his police interview, remember, during the initial pre-recorded hearing.
So the initial opportunity was missed, and that was that.
Essentially. She was, according to the judgment, dismissive of concerns raised, including those by the prosecutor, that a jury might face difficulties or that the defense might be hampered in relying on the mother's alleged motive if it wasn't put directly to the children.
So the judge essentially said, you had your chance at the pre-recorded hearing, and protecting the children from repeat testimony is paramount now.
Exactly. She prioritized the policy of protecting vulnerable witnesses and the finality of that initial process. She found the defense's initial omission was their responsibility and didn't create procedural unfairness needing a recall. The door seemed shut.
But the defense wasn't ready to accept that. Which brings us to Act 3, the appeal.
Right. Undeterred by Judge Trail's refusal in the district court, PJ's legal team escalated the fight further. They filed a notice of appeal on the 8th of March, 2023.
Where to?
Seeking leave permission to appeal her honor's decision all the way up to the New South Wales Court of Criminal Appeal, the CCA.
The highest court for criminal appeals in the state. And getting permission to appeal pretrial rulings there isn't easy, is it?
No, it's a significant hurdle.
And who was representing everyone at this critical appellate stage? Any changes?
For the appeal, PJ was again represented by his new team, M. Avenel SC and S. Orman Hales, still instructed by NFK lawyers. So consistency there for PJ.
And the Crown.
Here's the change. The Crown, now the respondent referred to as the King, had a different legal team representing them, M. Kumar and S. Beaumont, still with the Solicitor for Public Prosecutions as their solicitors, but different barristers.
And this change in counsel for the Crown, you mentioned it became notable.
Yes, because their position shifted significantly from what Mr. Robinson had argued in the district court.
Okay, so the high-stakes hearing convened on the 8th of May, 2023, before a bench of 3 experienced justices of the CCA, Baston AJA, Walton J., and Hamill J. What were the core arguments?
PJ's appeal rested on 2 main pillars. The first was that crucial threshold question. Could the CCA even hear this appeal? This was about jurisdiction, specifically under Section 5F3 of the Criminal Appeal Act.
Was Judge Trail's refusal an appealable order?
Precisely. The defense argued her refusal to recall the children was an appealable interlocutory judgment or order, basically, a significant pretrial ruling that affected the substance of the case and could be appealed before the trial itself.
And the second pillar?
That concerned the merits. If the CCA found they did have jurisdiction, did Judge Trail actually make an error of law in refusing the recall application?
And this is where that shift in the Crown stance becomes really stark at the CCA compared to the district court hearing.
Absolutely. In complete contrast to Mr. Robinson not opposing the recall application before Judge Trail, the Crown at the CCA, represented by their new counsel, now vigorously defended Judge Trail's refusal.
What was their argument?
Their primary argument was that the CCA lacked jurisdiction. They argued Judge Trail's ruling was simply a case management decision or maybe an evidentiary ruling about the scope of cross-examination, not an appealable interlocutory order.
And on the merits, if the court got that far.
On the merits, they argued Judge Trail was correct. They strongly emphasized the policy of protecting child witnesses from repeated examination, pointed to PJ's delay in bringing the application, and argued that any reliance by the defense on the rule in Brown v. Dunn was misconceived when applied against an accused person in a criminal trial.
So a complete turnaround from the position in the district court, that's quite something.
It is a striking illustration of how the prosecution's legal strategy can evolve between different stages of litigation, especially with different counsel involved.
Okay, let's quickly name the justices who had to decide this complex appeal again.
Right. We had Bastin AJA, who authored the leading judgment for the majority,
Walton J., who agreed with Bast AJA's majority judgment.
and Hamel J., who authored a powerful but ultimately dissenting judgment.
So Judgment Day arrived just over a week later, on the 17th of May, 2023, and the court was split.
Yes, split on the crucial issues.
So majority Bastin AJA, with Walton J. agreeing, what did they decide?
They delivered a decision that effectively shut the door on the appeal at that stage. They dismissed the application for leave to appeal primarily on the basis of lack of jurisdiction.
They found they couldn't even hear the appeal properly.
Correct. Bastin AJA concluded that Judge Trail's refusal to permit the recall of the children was not an appealable interlocutory order under Section 5F of the Criminal Appeal Act. In their view, it was more like a ruling limiting the scope of cross-examination or refusing to let a party reopen its case.
It didn't have that finality needed for a pretrial appeal.
Exactly. It lacked the necessary character and effect of finality required. They also briefly touched on the merits, finding no error in Judge Trail's decision anyway.
Reinforcing that one bite at the cherry idea.
Yes, reinforcing the strong policy of finality for pre-recorded child evidence, and stating that just changing counsel or strategy wasn't a good enough reason for recalling the children.
But Justice Hamel had a very different view. The dissenting voice.
A starkly different view. He firmly believed the CCA did have jurisdiction to hear the appeal. He saw Judge Trail's decision as indeed an interlocutory order because, in his view, it effectively and finally disposed of a discrete issue. The issue of whether the children would give any further evidence specifically on that critical topic of their mother's alleged influence.
And on the merits, did he think Judge Trail got it wrong?
Yes, he found that Judge Trail had erred in law in refusing the recall. His main reasons were that she failed to give proper weight to something profoundly important: the crucial significance of the mother influence evidence to PJ's entire defense case.
Especially since PJ had raised it from the start.
Exactly. Raised it in his police interview, and even the initial prosecutor in the district court had seen value in testing it. Furthermore, Hamel J. felt Judge Trail had over-relied on the availability of a General Jovanovich direction as a sufficient fix.
That's the direction about the Crown's burden and the accused not needing to prove motive.
Right. Hamel J. argued that such a general direction, while important, couldn't adequately cure the specific prejudice caused by the defense being prevented from testing their specific positive theory of fabrication with the key witnesses themselves.
So the split decision really laid bare a fundamental judicial disagreement, didn't it?
Absolutely. It highlighted this core tension about when pretrial rulings, especially in these sensitive cases, can actually be appealed.
The majority prioritized trial continuity, setting a high bar for appeals they saw as procedural.
Yes, wanting trials to proceed without delay. While the dissent favored earlier appellate oversight when a ruling appears to critically impair an accused's fundamental right to present their core defense.
Arguing that waiting might mean an unfair trial just goes ahead.
Precisely. A real division on approach.
Okay, so what was the immediate consequence of the Court of Criminal Appeals' majority decision for PJ?
Well, the sources make it crystal clear. The children, FJJ and MLJ, would not be recalled for further cross-examination at this stage of the proceedings. That route was closed off.
So his trial had to proceed.
His trial for the alleged sexual offenses against his daughter would have to proceed without his defense team having directly put to FJJ and MLJ his core theory that their mother, MD, had influenced or fabricated their accounts.
How could the defense even raise it then?
They'd have to try indirectly, perhaps by cross-examining MD herself, assuming she was called as a witness, or through submissions to the jury trying to draw inferences from other evidence presented at trial. Much harder, tactically.
But it's important to understand, this CCA decision doesn't necessarily end PJ's ability to raise this issue entirely, does it? There's still a potential path.
That's right. The sources make it clear that should he ultimately be convicted after his trial, he can still argue on a subsequent appeal against that conviction.
Arguing what?
Arguing that the inability to cross-examine the children on MD's alleged influence stemming from both the initial omission during the pre-recorded hearing and the subsequent refusal to recall contributed to a miscarriage of justice.
Would that succeed?
Well, the success of such a potential future appeal would depend very heavily on exactly how his trial unfolds, what evidence about the mother's alleged role actually comes out, and the nature and adequacy of the trial judge's directions to the jury about these really complex issues. It's a pathway, but definitely a challenging one.
So PJVR has definitely left its mark on Australian legal practice, or at least reinforced certain principles with, well, stark clarity, particularly in this sensitive area.
Oh, absolutely. Based on the commentary and the judgments themselves, here's how. The most significant takeaway, often referred to as the one bite at the cherry principle in this context, is just how unforgiving those initial pre-recorded evidence hearings are.
Unforgiving how?
The majority's judgment really underscores that legal counsel must be meticulously prepared. They need to understand that they will almost certainly have only one opportunity to question child witnesses on all aspects of the defense case.
No second chances.
Pretty much. Omissions made by initial counsel, even if they relate to the core defense, like PJ's allegations from his RSP, are, quote, exceedingly difficult to rectify later. Simply changing your legal team or deciding on a new strategic approach down the track is very unlikely to be enough to get leave to recall.
That places immense pressure on the counsel doing those initial hearings.
Huge pressure. And it highlights potential implications for things like legal aid funding for complex preparations, briefing practices to ensure experienced counsel are involved, and it really throws light on that tension between rigorous procedure, which is designed for child protection and efficiency, and ensuring overall trial fairness if crucial defense angles remain untested with the key witnesses.
So it's a stark reminder to defense lawyers in these cases.
Yeah.
Get it right the first time, because there likely won't be a second chance to put crucial points to the child witness directly. A lot riding on that first interaction.
Precisely. The case also offers really valuable judicial commentary on navigating other legal principles, like the rule in Brown v. Dunn, and the use of Jovanovic directions, specifically in these types of trials.
What did it say about Brown v. Dunn? The rule about putting your case.
It confirms that Brown v. Dunn isn't applied with the same strictness against an accused in criminal cases as it is in civil cases.
Yeah.
However, as Justice Hamill's dissent powerfully highlighted, failing to put key defense propositions still carries severe tactical disadvantages when it comes to the jury's assessment of witness credibility. It makes it much harder to argue later that the witness wasn't given a chance to respond.
And the Jovanovic directions about motive.
Right. These are important directions reminding juries that the accused doesn't have to prove a motive for a complainant to lie, and that the absence of an apparent motive doesn't automatically mean the complainant is truthful. But PJVR shows that a general Jovanovic direction isn't a complete fix.
Especially when the defense is making a positive claim.
Exactly, especially when the accused is running a positive case, alleging a specific fabricated motive, as PJ was with his mother's alleged influence. A general direction, Hamilton argued, may not be sufficient to cure the prejudice caused by being unable to test that specific theory with the key witnesses.
So, trial judges and counsel need to think carefully. Relying solely on a standard direction might not be enough for overall trial fairness if a core defense theory is left hanging, untested with key witnesses.
That's the implication. It stresses the need for careful consideration in each case.
Ultimately, then, PJVR stands as a vivid and, I suppose, quite poignant illustration of that enduring dilemma the justice system constantly faces.
Yeah, balancing the absolutely crucial need to protect vulnerable child witnesses from potential trauma with the accused person's fundamental right to a fair trial and the ability to fully contest the allegations against them.
And the judgments in this case, particularly that sharp divergence between the majority and the dissent, they really illuminate the complex, often heart-wrenching terrain that courts in Australia have to navigate, don't they?
They really do. They underscore the profound responsibilities placed upon everyone involved in the legal process: counsel, solicitors, the judiciary alike in these most sensitive and challenging cases, where the quest for truth and justice has to somehow accommodate the vulnerabilities of children and the foundational principles of a fair criminal process.
Well, that was quite the journey through the legal system, from a deeply entrenched family dispute exploding into criminal allegations.
Yeah, through critical pretrial hearings with changing legal teams and the surprising shifting positions.
And finally, to a divided appellate court grappling with fundamental legal questions about procedure and fairness. The case of PJVR is a powerful story, isn't it? Of legal strategy, procedural barriers, and the very real human consequences of a system striving, sometimes imperfectly, to balance competing interests.
Absolutely. And its legacy in NSW criminal practice, particularly for child sexual assault cases handled under that pilot scheme, is undeniably clear. It highlights the critical importance of counsel getting it absolutely right during that first and often sole opportunity to question child witnesses. And it shows the significant legal hurdles that must be faced when trying to revisit those sensitive moments later down the line.
And that leaves us with a final provocative thought for you, the listener.
This case raises fundamental questions, doesn't it? About the precise balance the justice system must strike. Can procedures designed with the best intentions, to protect the vulnerable, inadvertently restrict an accused's ability to fully present their defense?
Especially when their defense is a positive assertion of fabrication by another party, like here.
Right. What happens when the echoes of unasked questions central to the defense theory, might significantly influence the search for truth and justice in the courtroom?
It's a complex challenge with no easy answers.
Definitely not.
Thank you for joining us on this deep dive into PJVR. We hope this exploration has given you a clearer understanding of the case's drama, its journey through the courts, and its lasting significance for legal practice.